Hey guys, how are you? Nice to see you all here. I'm so sorry we are a little bit late, as always. Big Amish, how are you? Welcome.
Great. Hi, Wendy. Hello, everyone. Hi, Alicia. Hi, Timu. And
Timu, how are you? Alicia, nice to see you. I'm so sorry. I'm going to get back to you as soon as possible. I did not forget. It's on my calendar. But yeah, so me and Big Amish have been chatting quite a bit now backstage, and I don't know who has seen Big Amish's video. By the way, Big Amish, excellent video.
thank you. That's right. That's biased.
No, I had other people look at it and they were saying, okay, wow, this is worth seeing. Definitely worth seeing.
Well, thank you. That's very kind. Well, hasn't been for you, I wouldn't probably be doing this
That's
and looking
kind.
into things
We
like this.
have, yeah, you've put together quite a lot of insights into this. And so I think you guys just, you congratulate Big Amish. She's been working right through the night. We've got something exciting coming up as well. We'll discuss that also in the live. So if he pulls the skull and falls asleep, then just excuse him.
Yeah.
But I don't think so. I don't think so. And we love Scully. We're just laughing because sometimes he does that and he'll drift off on us because he goes for hours and hours. But yeah, so this last video of yours was very, very interesting. I think, uh, do you want to tell us a little bit about it before we play the video, Big Amish?
Well, yeah. Well, the whole thing centers around recent statements, public statements by Steve G regarding plea negotiations, an Alford plea, and Judge Hippler being directly involved. Now, that's a problem,
Mhm.
especially given, right? It raises the question of a conflict of interest, an appearance of impropriety, where the judge has been involved either in closed door sessions, because I don't believe there were any public hearings in which Steve G and the judge were discussing the pleas. So it raises a whole other question of where these plea negotiations happened. They happened behind closed doors. Who was involved? And was BK present, or at least his counsel? But if the negotiations are going on, usually the defendant is going to be there. And again, this is all just my opinion. This is
Mhm.
just commentary. This is not legal advice at all. But having said that, let's back into the Judge Hippler issues. So you have Judge Hippler, who at the time of the plea was presiding over a leaks investigation that could impact the trial and BK's Sixth Amendment rights. We have that outstanding, and it was silent. There was no ruling, nothing, no finding. So basically, Judge Hippler was sitting on that. And then we have is it a forced or coerced plea? I think it raises that. It suggests that. You have the governor of Idaho, who has now sanctioned the firing squad and training them. So that's there. The death penalty's there. You have BK's affidavit in which he states basically that he was maintaining his innocence, basically a de facto Alford plea. Even though
Mhm.
in the forms he says it's not an Alford plea, it's a de facto Alford plea. It's suggesting something was going on behind the doors here and negotiations were going on. Steve G affirms that. He says they were pushing an Alford plea. That's his statements, not mine. I'm just going by what statements are out there and how you can convert that into an affidavit to support what we're talking about. And the video sets that forward as well. You have Judge
Mhm.
Hippler. You have Judge Hippler also giving biased references to Cy Ray, calling him a conspiracy theorist.
Yeah.
In a vacuum, one thing may not just jump out and say, okay, this is a basis for recusal. It may or may not. But in totality, when we're looking at even State Prosecutor Thompson stating there was no need for an allocution, that BK would be lying. He'll be full of lies. And we don't,
You said that?
yeah, and you pointed that out when we last spoke. And that's what got me thinking. I said, you know what? I didn't really look so much into the basis of a recusal, but also of undoing the plea based on Judge Hippler's conduct throughout. Okay. And then more importantly, focused on the plea. He went from, you go from pleading not guilty to guilty. This change of a plea position is critical. Why did it happen? We could speculate. We know certain things happen. We know that the 68 teradump unindexed data was thrown on defense counsel. Do you think BK could go through 68 terabytes of data if he wanted to before trial in weeks? I think the answer is no. Could defense counsel do it? No, it's an impossibility. So when it's impossible, prejudice is presumed to the defendant, like BK, because your attorney is now ineffective as a matter of law. She cannot, and the rest of the defense team cannot fulfill their obligations, their duties to BK. I think that's clear. At least it's plausible.
Can I cut in quickly there
Yes.
just to give everybody an indication? I did look it up. It would be impossible because, just to give you a bit of an idea, if you're watching, the 68 terabytes dump, if you put it into perspective, its equivalent size is about 3.4 million hours of high definition video, or 4.5 billion pages of text documents. So if you look at it that way, I worked it out. The defendant and their legal team, well, they had 4 weeks, 672 hours before trial. So they would need to review 5,000 hours of video content every single hour of the day and night to clear the data. Okay.
Yes, you're 100% right.
It's huge.
It's overwhelming. So, and just for the sake of argument, okay, maybe BK doesn't have to look at all of it, or so he could rely on his attorney, but the attorney is incapable of doing it. Even a group of attorneys, which they had, it is impossible for the defense to review unindexed data at that level. Impossible, and prepare for trial. And what did Judge Hippler say to Ann Taylor? I think, paraphrase now, you asked for the world and you got it, and now you need extra time, which was opposed by Josh Hurwitz for the additional time.
Yes.
So basically mocking her as well. And let's not forget Josh Hurwitz's role here. He went from a federal U.S. attorney for the state of Idaho to the state prosecution, special prosecutor. Under federal rules, Federal 16, doing that in federal court would be unlawful. The judge would say, "What the hell are you doing? You can't go. It's not going to." So if it's, so under federal rules, that's wrong what he did. But Idaho rules basically says you need to provide it and make it accessible. General, I've not researched it enough to get into the technicalities of it, but that's in a broad shell. That's what it is. So the state provided Ann Taylor with hard drives and all this data, right? However, it's stored on USB sticks, whatever it was, but it's still 68 terabytes to go through. And are the reports, and they're all unindexed, which means you have to look at every one to determine what's on there. and then you have to index it, add in metadata to the file, and organizing it. Could you imagine how much time it would take and costs in order to prepare
Yeah.
for trial? And at what time? How soon could you get through all of that data? Because it could be the last page, right? Could be this.
It could be anyway.
The last page that says something that that changes the case. So people have to realize what's going on here, and bring back Josh Hurwitz, because he knew that technical rule. In a way, you have somebody who knows he's getting away with stuff that he couldn't get away with in his other position. And why is he getting away with it? Because of Judge Hippler, in my opinion. Because Judge Hippler could have said, wait, you know what? He's never seen 68 terabytes, let alone 1 terabyte. I'll bet you he's never seen 1 terabyte to go through. So for him to make that judgment and to create the ineffectiveness of counsel, which Ann Taylor said would happen, right? She said that was going to happen, raises this prejudicial conflict and bias that Judge Hippler had during the pleas. So you don't take anything. You could take every act that he did independently. It may not amount to anything. But when you look at it collectively in the totality of the circumstances, you would see that he was biased in his views. So bias is just, if I could use, bias in a way is like due process. Due process is about fairness. Bias is a unfairness. So the 14th Amendment, the due process clause of the U.S. Constitution, the Fifth Amendment, applies to states through the 14th Amendment. That says basically the Constitution, these fundamental rights apply to the states. And so it applies. And Judge Hippler knows the background of Hurwitz. And knowing that it couldn't pass muster in federal court, why is he allowing it in state court? So this is all gamesmanship. This is unfairness. This is what I would call a violation of due process. So conceptually, I want people to understand about unfairness, what it means, and how it relates to the 14th Amendment, right? And affecting your Sixth Amendment right to counsel, effective counsel, or cross-examination, for example. So how do you cross-examine Othram if you're not allowed? How could you examine their algorithm?
Hey,
How
Lucy.
you don't know it. So yeah, how do you do that? How do you go behind the federal wall and cross-examine that material? You can't, because Judge Hippler said you couldn't. Told Ann Taylor in those orders, we're not going to let you see the federal grand jury subpoenas. We're not going to let you see who they were targeting, what crime, and when. All of that information.
What about Bryan Kohberger? Would he not have a right to see this also?
Well, those are his rights. That's what needs to be protected. I know we focus sometimes on defense counsel, but ultimately it is Bryan Kohberger's Sixth Amendment rights that are at issue, whether it's ineffective assistance of counsel or cross-examination. That's why in your other shows, Wendy, we talked about the ability of questioning, another term for cross-examination, right? Questioning those people who handled or developed or maintained the evidence. We know that was stopped because the feds were behind it. Judge Hippler says, no, you're not looking behind the curtain. We're going to stop you. And that's what happened. And what did the judge say? He says, you haven't proved prejudice. Well, that's like an oxymoron. How could you prove they're violating terms of service? They're violating what is essentially due process. He's saying, basically, he's telling Ann Taylor, I don't care what you think. I'm going to protect the federal firewall here, right? Even though it's a due process violation, in my opinion, and I think for a lot of people, it's a due process violation, what he's doing, because you had a reasonable basis for it. you had experts coming in, whether it's Vargas, whether it's Turvey, or whether it's Cyray, indicating the back door of evidence that was obtained by the feds violated or was missing. That was all stated there. That provides a reasonable basis to look behind that wall, in my opinion. Now it comes up in
You're right.
post-conviction relief.
And Lucy says here, I want to see Jennings and Balance be asked about Kohberger's timing advance. Yeah, it's going to be very
Yeah,
interesting.
because Jennings was handling that hearing, right? And she kept saying, she kept giving excuses. Oh, she believes that all that information was going to be provided. I think that was it. I'm sure Lucy. I could see the chat, just can't respond. I have my glasses, so I could respond to chat as well if there's some. But yeah, but you see how that's handled or was handled by Jennings and Hippler. And basically, Hippler goes, "Okay, yeah, that sounds good. You're going to give it, sure." We're all waiting, Jennings. It never came. And that's because they're all hiding. They're hiding the ball. But
I think I did speak about Jennings in a very early video where I did quite a while back.
yeah.
But there's a lot that's going to be happening now, guys. So,
Yeah, I believe the motion to recuse has to be the first thing. That has to be addressed. And I looked into the rules. Originally, as a matter of right, you could recuse a judge, but that's usually at the trial court level, or if there was a new judge at the PCR level. Because Judge Hippler sat at the trial level and now is the PCR judge, you have to show some sort of cause. And so that's why we have to look at everything Steve G says, Thompson says, the biased rulings. Again, the rulings are discretionary, but if you look at it as a whole, the totality of circumstances, it raises a huge red flag of a conflict, especially when you consider that Judge Hippler was sitting on an administrative investigation over the NBC leaks that tainted the jury of possibly, but he never ruled on it, no findings. He just sat on it, never was discussed. It's still going on, who knows? But why did he do it? So he doesn't have to rule on it. Because if he ruled on it and everyone, all eyes would be fixed. Well, and what would he rule on? It would also affect the trial date, in my opinion. I don't see how he could rule on a investigation unless he says, oh, there was no harm here. I don't know how he would do that. There was no harm and no violation of any order. I don't know how that would happen. And that's his problem, that he has evidence that he was sitting on and never ruled on. And he accepted a plea with no allocution, even though Idaho rules allow for non-allocution. Under these circumstances, it would be required to properly accept a plea in his position. That's my opinion. Because by maintaining or by being silent, it follows exactly what BK is now arguing or has argued in his PCR and affidavit, right? That he was tricked. All of this is trickery. It involves a combination of factors. But if we take Steve G at his word, which is kind of hard, but it provides a reasonable basis to get discovery into these issues. That's what it provides. The same thing with Thompson, because it fulfills the elements of a de facto Alford plea. That is no allocution, but they're bypassing the law, right? That Alford pleas require. That's all on the, that it's identified on the record. But to bypass that, in my opinion, based on what we've seen in public, that a reasonable basis exists to investigate Judge Hippler on this issue. And that's
Yeah, and I'll be telling you guys more about that a little bit. Do you want to have a look at your video? You
sure.
want to go through that?
Yeah, that would be great. Yes.
Okay, let's do that. Your video. There's so much coming up, it's almost impossible. Every 5 seconds there's something new. All right, let's do that.
And don't forget what Hitler said about Ray. That's also important.
Yeah, I think I'll add that to the stage as well. Let me make sure that this is playing properly. And then we can go ahead. Okay, got it on. Okay, you just tell me if you want me to stop at any points, but it's not a very long video anyways. Okay.
Bam! Welcome. Today we dismantle a conviction that claims finality while ignoring the constitutional floor. We are here to incorporate the power of Hunter versus U.S. into the very foundation of Idaho Rules 11 and 33. A guilty plea is supposed to be the end of the story, but what if the story was an illusion? This strategy uses the de facto Alford plea as its anchor. Roadmap is precise. First, we establish the non-negotiable federal baseline. Second, we expose the mechanics of the de facto Alford plea. Finally, we detail the judicial conflict trap created by parallel misconduct probes. The core question before us is twofold. Can a plea stand under Rule 33C when it is functioned as an Alford plea without heightened proffer findings? And can due process survive when a judge acts as both a mediator and an investigator of state misconduct? Let us be clear about our thesis. An unconditional plea under Idaho law is completely unenforceable if entered involuntarily or under structural error. This plea was the product of systemic coercion, discovery overload, and an unresolved judicial conflicts. The only legal remedy is to vacate the plea. Let's begin with the constitutional floor. State procedural rules do not exist in a vacuum. They are bound by.
I think just let me pause there so you can just go over what people are saying online when you talk about vacating the plea.
Okay, they're in the chat. Okay, so how do you vacate the plea? You have to show some structural fraud or the structure of the plea was broken. There was something wrong with that plea, either a conflict, right? Hidden information discovery, which we know about the 68 terabyte dump, bias. It could be bias of the judge, but also bias of an expert that now is coming to the forefront. Ray's statements now that BK is guilty and all this other information. It works twofold, but for purposes of PCR, we don't have nothing about it. Does not matter about the innocence of BK at this stage, in my for what we're trying to accomplish and evaluate. It's about whether the basis to vacate the plea exists. And
yeah, I think that's where a lot of people are getting confused on that point. Yeah, thank you for that.
yeah. Oh, and okay. And when they go through this constitutional floor, as we're going to hear, but I want people to understand. Again, this is just my opinion. State rules. Why? Some critics have said, "Oh, well, state court rules, don't incorporate miscarriage of justice under Hunter v. U.S." Technically, yes, but no. When a plea is a state contract under a state sovereign, right? State of Idaho. Those contract terms are under state law. However, there are federal questions embedded into the state plea, the state contract. Once those constitutional elements are waived, it now involves the federal constitution. So both can be true. You could have something reviewed under state rules and structure of a contract, but when you're waiving your Fifth, Sixth, Fourth Amendment rights, those rights are embedded in the U.S. Constitution, and whatever SCOTUS has opined on it is mandatory baseline for the interpretation of those waivers in that state contract. There's a term called inextricably intertwined. Try and say that 10 times real fast.
I can't.
Inextricably intertwined.
Yeah.
It's a great phrase. That means you can't undo one without the other. You can't say it's a state contract without acknowledging the fact that these waivers of federal rights exist under the U.S. Constitution. So once that's triggered and one of the rules are incorporated or is being interpreted, for example, the plea waiver or Rule 33 for manifest injustice, that's Rule 33C under the Idaho Constitution. When you interpret that, you have to use the baseline of the U.S. Constitution when it involves federal questions. Does that make sense? Because
Absolutely.
because the state contract, the plea, is intertwined with federal constitutional rights. It is at that exact moment that the baseline of SCOTUS in Hunter v. U.S. is indoctrinated into Rule 11 and or Rule 33C when it involves federal questions like the U.S. constitutional rights of BK. Okay, sorry.
Okay. 100%. Thank you.
The United States Constitution. Under the Supremacy Clause, state criminal rules can never fall below federal due process standards. Boykin v. Alabama requires a record that affirmatively shows a voluntary and knowing waiver. Idaho cannot use state plea finality to bury a fundamental due process breach. Let's look at the federal floor established in Hunter v. United States. The law is absolute. A defendant cannot waive the right to challenge a plea produced by structural, constitutional error, or coercion. Enforcing a waiver under these conditions results in a non-waivable miscarriage of justice. Incorporating Hunter directly into Idaho practice is guaranteed when it involves federal questions in the U.S. Constitution. Rule 11 cannot treat yes or no answers as a valid waiver when structural coercion exists. And Rule 33C, the manifest injustice standard, is the precise vehicle designed to enforce this federal guarantee. This table illustrates the hierarchy. The federal miscarriage of justice standard sets the floor. Idaho's manifest injustice rule provides the vehicle, and the 14th Amendment establishes the absolute baseline for voluntariness. Now, let's examine the primary procedural defect that most missed: the de facto Alford plea, evasion. How did this evasion occur, you ask? The defendant provided yes and no responses with zero narrative allocution.
Yes, right.
My name is Claire. When my first transplant failed,
The state acknowledged
Sorry.
his non-admitting state, yet the court accepted the plea without issuing the heightened factual findings required by North Carolina v. Alford. Let's listen to prosecutor Bill Thompson's own public concession. He stated clearly that there was nothing the defendant could say that would shed the actual truth. The state knew the plea was non-admitting. By taking the plea anyway, without Alford findings, they executed a structural bypass of the law. As this
Stop right
chart
there.
demonstrates, when a defendant does not personally adopt the factual narrative, the judicial burden rises. The court was legally required to make an explicit finding of an overwhelming
Stop right.
factual proffer.
You want to pause?
Although there are exceptions under Idaho rules, bypassing that step left a mess.
Okay.
Just want to point out again what we just heard from Thompson right in the video. If Thompson didn't believe BK that he would say falsities, then what did the court rely on for the truth in the plea? So there are exceptions to the Alford plea in Idaho, but you have to have the allocution supported by whether it's probable cause affidavit, the grand jury transcripts, something. I don't know if that's happened. I haven't dug into that. But even if it were that, even if the probable cause affidavit or the grand jury transcripts were used, which I doubt, but if they were, there's so much unreliability to them that whether it's Dylan Morrison, whether it's Molly McMichael, whether it's Bethany, whatever they were using or would use, because I'm not even sure that was even done. We just accept the fact that there was an exception to Alford and leave it at that. But maybe Lucy knows. But once,
Yeah, okay, let me have a look. I think Lucy did comment in the chat here. She said, okay, no, not that one. No, not that one. She might know about that. Lucy, if you do.
yeah. But you
So
see,
you're talking about the leak, right?
no, not the leak. We'll get to the leak. I'm saying.
Sorry, I skipped ahead. Sorry
Yeah.
about that.
No, that's fine. If the prosecution didn't believe that BK would tell the truth on the stand, and we know there's problems, which you talked about, the leak, the rulings, Steve G saying that Judge Hippler was involved in the plea negotiations. If you know he wasn't going to tell the truth, it raised the question is, what is the truth? That's the structural defect. Is BK now telling us the truth that he was lied to? And the lie could be that there was an Alford plea on the table. They changed it and gave him what's a de facto Alford plea. And
it was very telling when they said we can't trust him to tell the truth.
yes. So then there's no allocution. You know that he is not conceding what he's saying. So if he's not telling the truth, he's also not telling the truth for accepting the guilty plea for each of the counts. You can't have it both ways.
No, definitely not.
Okay, sorry. Continue.
This is something that does come up quite a bit because people seem to believe that he was truthful when he said, yes, I did this. But how can you accept that as truthful when, I mean, if everything was above board, they would have said even something. Tell us something. And you do see this happen in other cases. Tell us something that only the perpetrator would know, something that the media has not released to the public. Because
Yeah, what
there
could
would
you
be
parse out?
something. Pardon?
I'm saying, how could you parse out the truth?
Exactly. So something like that would be, okay, you don't have to tell us the whole story and everything, but tell us something, because they would always withhold something from the public, correct? That's not released. Something that they found on the crime scene, something that nobody knows about, and they would say to him, well, we need you to confirm this. Or at least we'll accept this plea, provided you tell us where you have put the weapon.
Yeah.
Right?
Yes. If you know that someone's not telling the truth, let me just back up 1 second.
Sorry if I go off track, guys.
No, this is important. This is very, very important. If you know someone is not telling the truth or would not tell the truth of how the crimes are committed, then by definition, you know that he's accepting the guilty plea under falsity. You know that. So it shouldn't surprise anybody, even the judge, that he's now seeking to vacate the plea. And to complicate things for Judge Hippler, he was presiding over a leaks investigation, which balanced the rights of BK to a fair trial or a tainted jury. He never ruled on that, which could have benefited BK. He didn't rule on it. Instead, he forced and accepted the plea that was defective. You can't be an investigator and also a neutral magistrate over someone's rights when you don't rule and they don't allocute. So even though the rule, again, remember we talked about that constitutional floor in a way, how intertwining the federal rights into state. So even though the rules of Idaho allow for non-allocution, you don't have to compel. The judge did not have to accept that plea, knowing what he knows internally, what he's doing, wearing the two hats, that he's not ruled on the leaks investigation, that he called Cy Ray a conspiracy theorist, that he denied Ann Taylor's motions to suppress, based on, he said at the end that there was no prejudice. Well, now you see the prejudice. You see and was he coerced? The governor sanctioned the rifle squad. The death penalty was on the table. Judge Hippler was going to allow all the evidence in to support a conviction. And
Yes.
all right. And what do you think? He's not going to admonish Ann Taylor if she tries to ask questions about federal agents and missing information? Of course he is. Of course he would restrict it and admonish her and make the jury feel that she's doing something wrong. There's no trust, in my opinion, of Hippler providing a fair trial under due process, the 14th Amendment. Remember that fairness prong. Is it fair, this conceptually, is it fair for Judge Hippler to not rule on a leaks investigation, to be involved in negotiations directly, according to Steve G., not making any findings, right? And then accepting a plea in which there's no allocution, in which the prosecuting attorney Thompson says there's nothing to believe. BK would lie about everything. So you know that he's lying in accepting the plea. That's a de facto Alford plea. And they were bypassing the rules of a true Alford plea. Why? Because the judge wanted this case over. He wanted it over, put behind him. And the 68 terabytes right before trial, and you don't, which is an impossible task to prepare for trial with all that information unindexed. Impossible for any attorney, anyone, to properly review that material, organize and maintain it. Impossible. So under Chronic, another Supreme Court case, under an impossibility of being effective counsel, prejudice is presumed. So that is a basis to vacate the plea in itself. But before you even get to an evidentiary hearing on vacating the plea for ineffective assistance of counsel, you have this primary issue just flashing at us. It's the conduct of Judge Hippler and his recusal. That gets done quick, fast, right? And think about the new attorney who's now assigned. Is he going to ignore the conflict of Judge Hippler? Because if you're going to have to review all that data, think how much time this is going to delay itself.
Are they going to have to go over all of that?
Well, it raises a question because now he's appointed as counsel for the PCR. So for a recusal motion, you have to show violations of the canons of ethics, which I think, neutrality being the main component of it. He was not neutral, right? And based on these statements of Steve G. and Thompson, raises the question of the integrity of the plea, that this is a de facto Alford plea. And if so, he was working behind the scenes to do this in order to get the case resolved. That is basically fraud in the plea, the structure of the plea. So that structurally the plea is wrong because of the judge's involvement directly and his
Of
rulings.
course. Yeah, for sure.
Then you have ineffective assistance of counsel. For the ineffective assistance of counsel, which also brings it in, because how could you be effective? So Ann Taylor is stuck there when the judge is not only pounding the table to Steve G, according to Steve G, of accepting or being involved in those plea negotiations for an Alford plea, but you have BK. Is he involved in these pleas? And he's watching this in real time. I mean, I'm just saying there's all this evidence that needs to be parsed through, and a reasonable basis exists to having a discovery issued on this narrow issue before you get into the 68 terabytes. Just on its face, what we see wrong, that's enough to at least have a hearing on recusal. That has to be raised before anything happens. So if there's a ruling, for example, if the PCR the petition is amended and they proceed in some capacity, the recusal issue gets waived. You can't raise it after. It has to be raised immediately. So the new counsel has to raise recusal immediately and have a hearing on that, separate and apart from everything else that BK filed, as far as IAC is concerned. Although it, again, that term inextricably intertwined relates to a lot of things, right? And so you have the intertwining of,
When you say a lot of things, do you want to just elaborate
a lot of
that?
things. So
Sorry.
yes, so you have a plea waiver that affects ineffective assistance of counsel, affects Judge Hippler, right? Affects an expert now who's come forward and applied guilt to BK, which would taint a jury. But if you knew about that, if you knew that an expert that was used in your case had a bias towards you, would you use that person? Would you feel comfortable? Would you feel fairly that he would treat you fairly in an expert opinion? I doubt it. That is a due process violation, right? So, and then you have Turvey saying things about Ann Taylor, that she was ineffective. Again, it doesn't matter whether it's true. It's the basis for it screams that there's due process violation of ineffective assistance of counsel, and also how this is unfolding that affects BK's Sixth Amendment rights. That's what's critical. And that's what opens up the door to so many things. And when, again, things, whether it's Judge Hippler's recusal, his conflicts, that has to be addressed, number one. So before anything moves into other evidentiary areas, or it could be combined, as long as it's raised, maybe a judge, if you conflict Judge Hippler and he's removed, by definition, you've supported a basis for an evidentiary hearing, because they're either relying on affidavits or the affidavits to secure the recusal of Judge Hippler. Maybe it's voluntarily, maybe he sees the writing on the wall. If he is exposed to having these closed door meetings or meetings with Steve G on plea negotiations that involve BK, in which he may or may not have been involved in, that's a big problem. Judge Hippler's recused and that plea is vacated. I hope I'm jumping around on different things, but hopefully you see the intertwining of issues overlaps so many times on different rulings or his conduct. So whether we're looking at the expert bucket, we see experts, the defense team, that structural element of a cohesive defense team is destroyed. We see Turvey saying things, we see Syre saying things, we see Ann Taylor saying one thing, that Brent Turvey violated his ethics. But still, that's enough. That's enough to show,
He did.
right? So that's enough to show that there was a structural problem in the defense team. which affects BK's rights. Because if they're squabbling over each other, and if it's before the plea, and did BK know about it? Did BK know all these things? And if he didn't know, he has every right to file a PCR, just based on that. Then you have Judge Hippler's rulings. Jennings, we could even use under state action under the 14th Amendment. You could use state action, taken as a whole, the totality of circumstances, violating due process and being a miscarriage of justice. So you could take everything that Judge Hippler did, his rulings, his statements to Ann Taylor, statements to Cy Ray, conspiracy theorists. That's bias. That's unfairness. That is a violation of the 14th Amendment, leading to a miscarriage of justice. But you gotta blend all of that, blend all those statements, acts, conduct, use Steve G's statements, use Thompson's statements, use Jennings' statements if she lied about providing them information, material about caste and the like. The fact that Othram, you don't have their algorithm in which they amplified. Here's just one thing on the DNA, on the 10 cells, I believe that's what it was, 10 cells of DNA. And I'm looking for Lucy or anyone to come.
I believe
10
it
cells
is
of skin
10.
cells, right? 10 cells of skin cells is what they collected, and they provided it, and they didn't get a hit, right? They couldn't use it. Why? Because it fell under the standard. I forgot what you needed, 18, 20 skin cells in order to do a test.
I think it was they needed over 20.
20, okay.
Somebody
So now
correct me.
you're falling below a standard. And remember, standard is something, think of standard, it's fairness, a standard. This is the cutoff. It's fairness. It's a 14th Amendment violation, due process. If you use something that you couldn't use, and this applies to, the trash bowl, the everything that they've done with the federal hand, they violated terms of service, for example. They're going behind the door. They're going behind the standard term of service, right? With the IGG work. But going back to the DNA analysis, going under the standard, that's not due process. That's number one. You can't. That's not reliable, because that is a baseline of unfairness. If the DOJ, FBI has a cutoff that we do not test under this, there's a reason for it, because it's unreliable. That's the reason. Don't have to look at the report and review it. Probably will after this, but there's a reason why they have standards, because once you fall below standard, it's unreliable. Does that make sense? So
Absolutely.
So when they give that to Othram to amplify it, now you have basically a second search, and they're using a standard that's not ever been used before. But if you listen to Middleton and his wife, it's totally reliable, and there's so much mountains of DNA collected. But once they amplify that DNA, those 10 cells, it's now tainted evidence. You can't use it. That's a violation of 4th, 5th, and 6th Amendments. It's unfair to use tainted DNA. That's what they did, even though they used an AI algorithm for which, again, defense doesn't get that information. So I'm sorry, you said something?
Yeah, the AI algorithm. Wow.
Yeah. So they use that amplification process, an AI algorithm, which no one knows what it is. But because it's proprietary, they're maintaining that. They simply assisted, right? This is the Judge Hippler basis for not allowing the motion to suppress or motion to compel regarding the federal hand, that the FBI was simply, the feds were used in a support role, and they were simply acting as an analyst. Well, we see here now how that second DNA amplification is an unreasonable search and seizure. It is a second search in which there's no warrant produced. The use of an amplification process that is untested, unknown to defense counsel, is a violation of due process. So you either have to open up the door and allow defense to question the integrity of the process, or you suppress the evidence. You don't allow the evidence in without the ability of defense to question or cross-examine. And that's what would have happened at trial. And you heard Middleton as well. And that's actually another basis to show coercion and bias. He said there was a mountain of evidence, of DNA evidence against BK. Well, why the hell is he talking about it?
Mhm.
And Steve
Yeah,
Jesus,
Tim, you're right. How on earth is it acceptable to use AI to grow the DNA? Is that why they don't want to show their work?
yes. Well, they're going to claim it's proprietary, and they'll show you their statistics, and they'll present statistics to, like, Detective Mowry or whoever would be in charge. I forgot whether it's him or the other bald-headed guy, Payne. I forgot.
Brett Payne, yes.
Yeah, but and they basically they just mimic, they parrot whatever they're told, and if the judge allows it, that parroting without the underlying data for defense to cross-examine and interpret and to challenge under due process, you violated the rights of the defendant clearly. I mean, it's not even. I don't think there's even a dispute on this. Oh, it just gets me so angry looking at everything that Ann Taylor was trying to do and just getting shafted by Judge Hippler.
Definitely. Let me play here a little bit,
Yeah.
and then we'll go.
Massive unconstitutional gap in the record. Now let's compare the three postures. A standard plea requires genuine adoption of facts. A formal Alford plea requires heightened judicial findings. The state of Idaho attempted to create a third, unconstitutional category, a de facto Alford plea, where allocution is omitted, but formal Alford findings are evaded. In public interviews blasted across mass media, Steve Gonsalves specifically names Judge Hippler as being involved in the plea negotiations, and also include Alford plea negotiations, highly suggesting that the requirements of the Alford plea have not been met, and this results in a miscarriage of justice. Now we turn to the conflict that corrupts the integrity of the proceeding, the judicial conflict trap. Under U.S. v. Davila and the 14th Amendment, a judge must remain a neutral referee. When a presiding judge actively participates in change of plea negotiations, they become a material witness to the voluntariness of the very deal they are validating. Now let's look at the dual roles assumed here. Judge Hippler was administratively overseeing the investigation into state media leaks regarding NBC and Dateline. Simultaneously, he was presiding over the plea negotiations. This dual role created an irreconcilable conflict of interest. Consider the timing. There were parallel leak probes, one administrative under the judge, one criminal under Ada County. The judge accepted the plea before the administrative leak probe was resolved, effectively forcing a waiver of claims before the findings of state misconduct were even known. This created an unknowing waiver as a matter of law. A defendant cannot make a knowing and intelligent waiver of rights when the presiding judge is sitting on an unresolved investigation into state misconduct that could yield suppression evidence. Next, we address the environment of structural coercion that rendered effective representation impossible. Right before trial, the state, under Dow Special Prosecutor Joshua Hurrett, delivered a massive 68 terabytes of complex digital and forensic evidence, forcing counsel to navigate this unindexed volume under tight deadlines weeks before trial, with a request for postponement denied by Judge Hippler, creating a constructive denial of counsel where prejudice is legally presumed. Under Strickland, which requires proving specific attorney errors and prejudice, chronic applies, when the surrounding circumstances make effective advocacy impossible. Forcing a capital defendant to choose between an unprepared trial or a coerced plea is the textbook chronic violation. This pressure was compounded by unresolved constitutional challenges, subpoenas, motions to compel, and motions to suppress, targeting FBI genetic genealogy records and raw cellular telemetry were suppressed, withholding core exculpatory evidence prior to the entry of the plea. Now, here's our strategic execution plan for post-conviction relief under this de facto theory. The immediate priority is securing sworn defense team affidavits detailing judicial participation in plea negotiations. This would also include obtaining the affidavit of Steve Gonzalez for his public statements regarding the Alford plea negotiations involving Judge Hippler specifically. At the very least, the public statements by Steve Gonzalez could be turned into an affidavit that could be signed by Bryan Kohberger. The sequence is clear. Move to recuse the trial judge as a material witness to negotiation coercion. Compel the unredacted leak probe files and demand a full evidentiary hearing on miscarriage of justice, which is now incorporated under Rule 33C, manifest injustice.
My work is easy because I use ClickUp.
Is that the
Here's
end?
how I keep track of all
Yeah,
my
that's the
tasks.
end.
I start by brain
Yeah.
dumping everything I need to get done in a list view. Next, I set a priority.
Sorry.
So what happens now? Prosecutor Rob Wood, Madison County,
Mhm.
Idaho.
Pause and take that off.
Yeah.
Okay. Wow. Okay. So that's pretty much everything we discussed.
Yes. And him being a witness, that is so crucial to what Steve G has stated publicly. There's no way around it. If he was involved in plea negotiations and BK now is raising to vacate that plea, there is no way he's not a material witness unless
Mhm.
it's redundant testimony. But you're going to get, it's almost going to compel affidavit from Judge Hippler. And whoever is going to be representing the state is going to have to show that, no, it's all redundant. Either he relied on the PCA, whatever it is going to come forward. But I don't see how you overcome what Steve G said, that he was involved directly in plea negotiations and that Alford plea was discussed and that he was sitting on the leaks investigation knowing that BK was going to waive his rights to them. That is a structural defect in the process of accepting a plea, in the plea agreement. So that's clear. And it's his position as judge, mediator, and investigator, and accepting a non-allocuted plea, knowing that the statements that he would say are false. How do you credit allocution if you know that he's lying? According to Thompson specifically, he said that. So it raises that question. There's no doubt that a reasonable basis exists to examine this recusal for cause. No doubt. Now, how are they going to challenge this? Is a whole other story. You're going to say it's redundant. They're going to try and shut down that plea waiver. But you have Steve G statements. You have Thompson statements. You have BK's statement that he was tricked. And I'm sure you're going to find defense counsel is going to provide an affidavit to that extent. That's all going to be there. Now, that in itself should be sufficient to get an evidentiary hearing on recusal. But it does also push Judge Hippler into an uncomfortable position of simply stepping down from the case and recusing himself. Because you also, the appearance of impropriety is what's present. That's a canon for judges. If there's or even lawyers, I guess, the appearance of impropriety of a judge that's a standard in order to seek recusal, right? And you
I'm going to
have
go over
that.
the slides. Let's go over that. Okay, let's do that. I'll share it so we can go over that.
Yeah.
Um,
And Lucy was bringing up the bioinformatics. So
yes, thank you for that, Lucy. Sorry about that. I
Yeah.
saw your link.
that's yeah. Does everyone know what that is? I mean, I need to get a better handle, but it's basically it's a science that's a computer programming with, it's the algorithm, I guess, but it's using computer programming statistics, and they use and they track large biological data sets. So, the DNA sequencing, the structure of proteins, for example. So it bridges kind of computer science with research tools and genetics. It's a whole new concept that hasn't been tested to pass due process, but it's new. See, and that's what feds use because they get ahead of the law. They use new technology as their investigative tools because by the time these cases get before the Supreme Court, they've already used them for 4, 5, 6 years. They got to get caught first. That's the sad part, which it shouldn't be the case. They should let the public.
Is that what you sent us, Lucy? I did see that newsletter. Okay, I'm just having a look at it. It's kind of like very short here.
Yeah. Oh, you want me to go over the Idaho rules for the recusal or affecting a judge?
Yeah, I'm going to put that up on the screen.
Yes.
Okay, thanks for that, Lucy. Wow.
Let me see what Lucy's saying here. But best. Okay. Harvard's Martin Nowak. Ugh. They should fight this. Okay.
That's the one that says Cybersecurity and Infrastructure Security Agency.
Oh, I can't see the video. I'll look at the video, but yeah,
Do
absolutely.
you want me to share it on screen? Hold on. I can share it on screen if you want. Let me
Yeah.
just try to do that.
Yes, Lucy.
Okay, let's
She's
do
right.
that.
Yeah.
I'm going to try and share that on screen quickly.
Yeah, and when you're putting it up, but do you see how you use new technology? And it could be different technology, not just this, but whether it's surveillance technology, all that, they get ahead of the curve and ahead of SCOTUS, ahead of the law, basically. And then they use the law to rein in, okay, this is our scope of what we could do legally. But first, they're busted for the illegality of it. Then they conform because the Supreme Court always provides some avenue for them to use the technology as investigative tools. Unless it's totally unreliable, then they throw it out.
Can we just try and put this on?
It's over an hour long, Lucy's saying. Oh.
It's not a video though. I don't know why I can't get it to come on the screen. Sorry about that. Oh, is it, Lucy, is it a video? Because the one was an article that came up. Let's just see here. The one Lucy sent me was an article. Is it that, Lucy? Oh gosh. Yeah. Sorry, guys. Let me see if I can get this up on here.
While you're doing that, should I comment on the canons, the rules regarding the disqualification? If you want.
Let me see if I can. Let me see if I can add this.
Okay.
I should be able to. Sorry. I'm going to remove that one, and then I'm going to just look at the one Lucy sent. If I have the right one.
I see she's, well, security flaws. If there's security flaws, then you have tainted evidence, right? The chain of basically got to look at it, that it's secure, that no one could tamper with evidence. And so I think what Lucy's bringing up in that Illumina, it's not just Illumina, it's Tech Radar. So security flaws. Security flaws are, are you by design? It allows a backdoor for feds to get in.
Okay, it's not letting me play this. I have to first do yours, and then we can look at that one. Okay, so let's look at your one first. Sorry about that. Lucy,
No
maybe
matter.
put the link. I don't know if I've got the right link in here, but okay. So on the first, the key governing Idaho rules. Can you see it?
Yes, I could pull it up and blow it up here a little bit. So the governing Idaho rules, you have Idaho Criminal Rule 25 and 40D. They provide the procedural mechanism for judicial disqualification with or without cause, right? In Idaho criminal and civil district court proceedings. The PCR is in a civil proceeding, so it's no longer in criminal. However, these rules apply. There is a matter of right to disqualify a judge, but you have to do it before any hearing starts. That's as a matter of right. But
Okay.
because of the technicality of Judge Hippler being the trial judge in the criminal case and now sitting on the PCR case, it requires cause. So you have to show one of the reasons to remove them. And then you look at Canon Rule 211, and it mandates disqualification. This is a rule, an ethics rule, basically, that applies. Whenever a judge's impartiality might reasonably be questioned by an objective, fully informed observer. So this is an objective disqualification, not a subjective one, not I believe this happened, but when you look at it objectively in the totality of circumstances to a reasonable person, would you question the judge's impartiality? So it's a reasonable person standard, an objective one that applies. And then the Idaho Constitution that applies, the fundamental due process, ensuring all litigants appear before an unbiased, objective, and neutral judicial officer. Now ask yourself, based on what we talked about, is Judge Hippler unbiased, objective, or neutral?
Definitely not.
Right. But even if, just to bring this back to the issue, even if the Idaho Constitution allows it, which it doesn't, but the federal miscarriage of justice is embedded again into this issue because it brings the judiciary into disrepute. So the Idaho Constitution could always provide more protections to a defendant, but never less than the federal baseline, the federal floor of the U.S. Constitution.
Mhm.
So that's that one. So anyone who has questions regarding the standard or how that's going to be applied? I mean, I think we went over that, but we could. Does anyone feel that there's a objective Judge Hippler out there as it relates to BK's rights? That's what this is all about. That Judge Hippler presiding over the PCR based on alleged conduct or stated conduct, both in public filings, orders, and or public statements by experts and Steve G. and Thompson. Do you feel that he is an objective, neutral judge, that not to be recused?
No, I don't think anybody feels that way.
Yeah. Yes,
We
Lucy.
have to ask, Ruthie. We have to ask.
I think he's objective. He's objectively against the rights of BK.
Against Bryan. Gotta ask. We have to be fair. We have to ask the question.
Well, it's a question for everyone to make on their own. Yeah, that's what the test is. It's an objective test of impartiality. So that's what's going to be tested. Now, Wendy and I are working on something that would require it's like a public service to address some of these questions. But Wendy will bring that up, I guess, at the appropriate time.
Yeah, we'll bring it up towards the end. We might need help from you, Lucy, on that.
Yeah. Let's see. What does BK stands? No, well, Lucy smile. Okay. BK stands. This is by Johnny Stewart. Stands no chance with this appointed attorney. No one can say there's too much to catch up on. Well, to be fair, that 68 terabyte dump, Johnny, is an impediment. It's an impediment now on many levels. One, the attorney, even if you want to give him a pass, there's no way he could get up to speed unless it becomes indexed, and maybe that's been done, so that'll help. And if it's not been indexed by the defense, has the prosecution gone through it and maybe indexed it? Because this might be coming into the court anyway. And how is the court going to review unindexed information and data? So again, due process.
Do you want me to go to the
PCO
next
level.
one?
Yeah.
Okay, let me go to the next one here. Okay, we did cover this. The second
The
one,
reasonable
right?
person. Yeah, we did it. We kind of did. It just talks about, okay, we did
Yes.
that. We could go to the next one.
Oops. Okay. Tell me if I'm on the right one. No, I'm not.
The anatomy, or yeah. So the anatomy of an objective conflict. Okay. Some of the conflicts arise from personal and economic interests. A good example of that is, and is when, let's say, a judge owns stock in IBM, and IBM is one of the parties before that judge. Well, either the parties have to consent to a potential conflict, and it depends how much, or maybe his wife or his son is working for IBM. All these issues come up that might have a personal and or economic interest in the outcome of the litigation. But it also involves familial relationships, professional or social relationships. So Judge Hippler, didn't he have in his law firm days as a partner? I'm trying to remember the name of the law firm. That law firm was then used in connection with the, I guess, the transaction transferring the property from the owners to the university. Could that be viewed?
Possibly. Mm-hmm.
That's one thing. But you see how it gets further away from direct relationship. But that's one, personal and economic interest. Personally, he wanted this case over. If you're involved in plea negotiations and you're trying to force it down someone's throat while you're sitting on a investigation leak, that goes to the whole other conflict that we're getting into, the dual role conflict, the administrative and dual role conflicts, right? So this arises when the administrative judge, such as Judge Hippler, oversees the administrative discipline or litigation orders or proceedings involving the same parties? Well, we know that there was administrative leaks investigation going on, and it was being looked into the state. Now, the irony is that Turvey said he was contacted, right? And he mentioned
Yeah.
he was contacted. This raises a Gabby Vargas situation. Well, who contacted him? Was it just
Yeah, we covered her as well.
so?
We don't know who
Yeah,
contacted her.
and what was it for, and when? Was it before the plea? After the plea?
Didn't they go to her, to Gabby Vargas?
Yes, the FBI.
I think that's how she was contacted. Tell
Yeah,
me,
before her
am I
statement.
correct?
Yeah. But the same things would be happening here. You know, what works, the modus operandi for influencing witnesses or testimony, right, is exactly that. We saw that play out in real time. And you don't think it's happened in the leaks investigation? You know, that's something to look at. And what about the hats that he's now wearing? So if you're putting on an investigator hat in which you know affects the rights of BK, which could infect the trial, and you stay silent on that, and you force the plea in order to just end it all, end the case, you violate BK's rights. You can't bypass that conflict. And we still don't know what the results are, but that's meaningless because the state is going to argue, well, you waived it. You knew that this investigation was going on. But going to the recusal issue, that's where this gets interesting and why a motion to recuse is so critical, in my opinion, to get this ball rolling and moving and to remove Hippler. And
Let's go to
Hippler
the
is,
next one.
it's fascinating. And Hippler would be a witness. BK can now depose Hippler. Could you believe this? Technically, he could depose Hippler.
Okay, so that it say BK could depose Hitler.
So he could depose
Is it
Hippler
better?
once the discovery is ordered, or at least on this narrow issue. I believe that he's within his rights to obtain information from Judge Hippler, provided there's a reasonable basis to do so, which we know from Thompson, BK himself, and Steve G. of the de facto Alford plea, that there is a reasonable basis to question it. And the fact that he was presiding over an investigations leak. There's no doubt that BK has a reasonable basis to seek discovery and depose Hippler himself as a witness to the de facto Alford plea. Hopefully that makes sense, right? I'm showing the reasonable basis for it. He's a witness. Steve G put him in the crosshairs. Thompson says BK is untrustworthy. You can't believe anything he says. So if you can't believe anything he says, and you pointed this out, Wendy, how do you accept his plea to be truthful? The judge, this case is over, ladies and gentlemen. It really is, in my opinion. It's going to unravel, but it may require steps ahead. The state might protect Hippler, but it's clear as day, and expect the affidavits to come in very soon regarding the recusal, the affidavits and a motion, and probably they'll be under seal until he's recused in order to save judicial quote unquote integrity. I'm sorry, go ahead. But I hope that's clear, at least from what I've said.
No, that makes sense. Okay, so we've gone over this personal knowledge. Do you want to go to the next one?
Yeah. Okay. There we go. Let's see that. All right. So let's talk about the 211 canon rule. Personal knowledge and bias. Mandatory disqualification if the judge possesses extrajudicial personal knowledge of disputed evidentiary facts in this case. Now, what's interesting, what did he know outside of the courtroom, in chambers, for example, or anywhere outside of that? If Steve G raises the question, where did his plea negotiations happen with Judge Hippler? Because we didn't see it on TV. I mean, publicly. I say TV being a video format. It raises that question. And Cy Ray's statements, and Wickham's as well, of obtaining information. So when Cy Ray said, for example, the device, he could pinpoint the device being in the home at 11:22 and the like. Now
Yeah,
he's
I'm
at,
going to put that on screen
right. But
after we go through this as well. Yeah, I found that.
if he's saying that, how did he get that? Did he have a top secret security clearance? How was it provided? Is it suggesting, and I'm raising it here, is it suggesting that certain information was provided to certain people? Would that have included Judge Hippler during plea negotiations? Because Cy Ray said if the evidence comes in, 10 out of 10 courts or juries would have found him guilty. And I could tend to agree with that. And the reason is, if you allow misleading, unreliable evidence into a case that involves, the magnitude of 4 unalivings, it'll be hard pressed, and you see the families there and the emotions. It's going to be hard pressed not to obtain a conviction by a jury. So, okay. Prior legal representation, required accusal. The judge served as a lawyer. No, he didn't practice with a lawyer who handled the dispute during their association. To my knowledge, no. We raised the issue of him being a partner long ago, and involved the law firm that was involved in the transaction of transferring the property of 1122 to the university. So that's not there. Economic and proprietary interest. Absolute prohibition. A judge, spouse, or minor child residing in the household holds a financial interest in the subject matter or party. I don't believe that's the case. Could be wrong. I don't know what his wife does.
Which points are you saying here? Sorry.
Economic proprietary interest.
Yes, sorry, let me look closer. I'm also a little bit
Yeah.
blind. So it says, what? Absolute prohibition if the judge, spouse, or minor child residing in the household holds a financial interest. Oh, no, not that one.
Yeah. We don't see that. But appearance of partiality or impropriety. It's a broad mandate requiring self-recusal. It forces the judge, whenever circumstances create a reasonable perception of compromised judicial neutrality. So, if the judge was involved in everything we just discussed, plea negotiations, directly trying to force a Alford or discussing Alford plea, he's presiding over the investigation leaks investigation and doesn't do anything, and you have a change of plea in which the defendant does not allocute, does not provide any narrative, and you have Thompson stating there's nothing to be believed by BK allocuting because he's not going to tell the truth. So if he's not going to tell the truth about what happened and how it happened, how could he be telling the truth that he pleads guilty to these crimes? It's an oxymoron.
Absolutely.
So, and that's why I feel strongly that this case gets, this is the Achilles heel of the case right now, is the judicial misconduct that we've pointed out. That's front and foremost of anything that's going to happen in the case, or should happen. I'm not saying it is, but it should, in my opinion, and I think in a lot of people's opinion after hearing it. Okay. What else do we have? Is that it? Or
That's the last one we're going to.
yeah, that's the so yeah, that's it. The rest of it is. Oh, if you go to what is it? I forget, the procedural rules, the timing. It's just you have to do it now or it's waived. If you have a hearing on anything else with Judge Hippler, potentially you've waived that conflict. But the duty is really on Hippler. He knows the hats he's been wearing. He knows the conduct that he's been involved in. That's what's so critical here. The only way to keep this concealed more is that they allow Hippler to remain on the bench and they kick the bucket down the road to federal habeas. But the affidavits in support of these conflicts should and must be filed at the PCR level, in my opinion, to preserve it for federal habeas in raising the judicial disrepute argument of the miscarriage of justice in Hunter.
Okay, let's go to the next one. Oh, sorry, I don't know why this thing's. Okay, let's go to 7.
Well, you
Okay.
can bypass that. Bypass that. I
Okay.
think I was talking about
About
at the
that
end, I
already.
think. Yeah, the frequency of it. But here, the rules, the timeliness of it. So, generally speaking, without cause, yeah. But we're dealing with cause now. Without cause, you could file it within that window, 21-day window, following an initial appearance. But Judge Hippler has to be recused for cause, right? For cause. So that's the second part in that. Motions alleging objective conflict or cause under Canon 211 must be filed at the earliest practicable opportunity upon discovering the factual basis. Now, if I found it, other people should find it as well.
Yep.
But it raises a question. Once you're appointed counsel, the client doesn't have the right on how the legal arguments or the legal theories are presented. So if this new attorney does not believe there's a conflict of interest and doesn't file it, if it's in his professional opinion that an objective standard of recusal doesn't exist, he doesn't have to do it, and he doesn't have to be forced to do it. This is the interesting thing. Hopefully I kind of articulated that right. So basically, this
So you're saying
attorney,
the new attorney, if he doesn't do it,
if he feels that there's no objective basis to recuse Judge Hippler, he doesn't have to file. If he does believe that, then he has to file that motion fairly quickly. And so his argument's going to be, well, I don't know enough. I need to look at, has to look at the record. He has to review the file. Is he going to look at the public statements that we're talking about? Because you could turn them into evidence. I mean, it shouldn't be new to him. So, but it raises the question, is BK going to get a fair and neutral independent counsel appointed to him? That's kind of a next prong. Is that what we see here? I don't know much about this person at all. I've not read. All I know is the name is Ralph.
came up a little bit on Monday. People are not too happy with him.
Okay.
Just quickly, let's look at a comment here. Lucy said, the state gave the defense the AT&T CDRs with timing advance records for Maddie, Sana, and Showalter. So that's Jack. There's not any NATSEC reason that the same records relating to BK couldn't be shared. Oh, yeah, I agree on that. What do you think about that, Big Amish?
Yeah, I mean, if again, it's a due process issue. You can't give some, that's the pass by Hippler. You can't give some evidence that was requested and consider it due process when it's the defendant's rights, BK's rights, that are at issue. They need those records for a proper qualification or cross-examining the quality of the evidence that's being used against BK. So there is no reason for that to be withheld. Certainly, there's that in itself is a reasonable basis to challenge those records and suppress those records. If you're not going to give BK's AT&T records, giving alleged third parties, records does not satisfy due process. Not any day of the week and not twice on Sunday. Right? Does that make sense? How if you're not giving the person whose liberty interest and life interest is at stake, if you don't give the records that assist in his defense and his counsel to assist him, how could it be due process? How could that not be a Sixth Amendment violation? But, that's one order. He denied it. But when you look at it in the totality, and Lucy's right, if you look at the totality of all these rulings by the judge and how he handled them, you could see an inherent unfairness all the way through. And it leaves unfairness at the doorsteps of the feds and every backdoor that's available to them, in which they basically conceal by using backdoors how they obtain evidence and used it against BK, and Hitler allowed it. That's the due process violation. That is a constructive fraud involving a judge even. And then
Everything redacted says here, isn't BK's new attorney in a Facebook page for him being guilty? I believe so, yes. I believe there was. Sorry, Big Amish.
No, not at all. He was found guilty for something?
No, what she's saying here, his new attorney is in a Facebook page for, I think he was commenting on Bryan's guilt.
Wow. So there you go. It's basically.
I just wanted to bring it up because I thought you might find that very interesting.
It is. Absolutely. It's just like Ray. Again, in my opinion, those statements help BK at the PCR level. It's not about his innocence at the PCR level and beyond. It is about due process. And if you have a biased expert, biased judge, or biased attorney, you have violated, you being the state, or the PCR, or I'm sorry, the plea is structurally defective at that point. So it should be vacated. The fundamental unfairness is downright. It's all over the place. Every other day, you're getting statements from somebody giving more evidence about BK that we never knew about, of being guilty. So,
Absolutely.
that was great. That was great. So he shouldn't be the attorney if he made that statement. Now,
is he not just a temporary attorney for the filings?
Well, that's not what Judge Hitler ruled. I think it's for the remaining.
I'm not sure. Somebody just
PCR. It's for all the the rest of the PCR reviews, but it raises a question, right? So if he goes ahead, does BK know this? Does BK know that this attorney said that? And let's look at the attorney's argument. Oh, that's when I didn't know about the case. Now that I know about it, I don't believe he's guilty. I mean, it just raises the question. There's semantics, there's mental gymnastics around these arguments. My whole point of raising it is, how is the state going to protect Hitler on the bench to maintain presiding over this PCR? And so he could shut it down. He's going to buy time now, I believe. But either way, either quickly, I thought he would dispose of it quickly. And that if he does that, he needs kind of the assistance of the new attorney to get things rolling in that fashion. So he'll dispose of the case, in my opinion, fairly quickly, or it's going to last forever. I don't see it lasting forever, but he might
hope
want to
not.
wait past that September 2nd, 3rd date to amend anything. And
Lucy, I hope not. And everything's redacted said, I saw Phoenix. I don't know that channel, but anyway, trying to raise money for him for an attorney. Well, is this something that we are allowed to do for Bryan?
as a member, oh, you're talking about the petition we're talking about?
No.
Oh.
So if Bryan has been appointed this attorney from the state, can the
Yes.
public raise money to help get him
No.
a proper
I mean,
attorney? Or not?
well, I don't know how that's done. That's beyond my wheelhouse of knowledge. I could look into it. But in order to raise money, he has appointed counsel. That's what he asked for. If you're raising fund of monies for something he's not even asked the public to do,
Okay.
you're
Okay.
acting as an advocate in a whole different capacity. That could
No, she
potentially,
is saying here,
you could be
I believe you're
violating
supposed
the
to ask
attorney-client.
him. So there is a mailing address. I don't know. I mean, maybe you'd know, Big Amish, if there is a mailing address where we could mail BK, would he get the mail? Wouldn't he?
Well, you could send that to the prison that he's being held in, but
Mm.
money, how are you going to put the money in? So you put in his commissary.
That is something that I wondered
if you-
about now as this was brought up, because I have seen people mention this online, but
Well, if someone sends cash by mail, I could almost guarantee that cash will not make it past the the guards who would hand over the mail or the mailroom.
yeah,
Because
just I know it sounds like a silly question, but it was
no,
something that also crossed my mind.
it's not a silly question. It's not a silly question. I just know someone who did that, and that's the only reason
Really?
I know.
Okay, no,
Not in
I
this
just
case, but it's some try to help somebody. That's what I understand. I could be totally wrong, but the only way to do it is through his commissary. I guess they have like a internal bank basically, but you could send money to his commissary at the prison. But I don't know what it
probably
requires.
that would be one way, or another way would be if anybody had access to his family and the money went straight to a GoFundMe for his family, I think.
That
Would
yeah,
that be another
that could work.
possibility?
That
I
could
think
work.
there would be a safety net so that, for us, I'm always skeptical. And so I don't know Phoenix. I haven't seen that channel. I haven't watched too many channels on this case, trying to just keep my thoughts on what I'm doing here. But so I'm not saying she's doing it. I think the problem arises with that is everybody has a good intention, but we've got to be really careful if we want to go that route. Who's going to manage those finances? How much would you need to raise for a proper defense attorney? So you better have something where
It's going to be in the millions.
yeah.
If you're talking about 68 terabytes, right? It's that's the problem is.
Yeah.
But if you're going to
Because
raise money,
everybody's saying get one attorney, but obviously with that amount of data, they need an entire team. Remember in the beginning, I said it's going to take them 5,000 hours every minute or
yes,
every hour, 5,000 hours to review. So imagine how many people this attorney would have to retain to go through all this footage. How much do you think something like that would cost, Big Amish?
oof, you have to get vendors. One issue I have would raise before is, has it been indexed? It might be indexed now, which would save a lot of time, right? And the software vendors and the like. But if it's unindexed, and trying to get all that done is, we're talking just the indexing and making it searchable for your staff or someone to go through and manage is going to be in the hundreds and closer to probably $1 million, in my opinion. Could very well be more than that. I don't know what the status or of the evidence is, how accessible it is, what was it placed on exactly. I know there were hard drives and certain devices and data, but it's going to take a lot. And if you're going to take on a case like this, you want it indexed and indexed properly.
Yeah, so possibly maybe if any of you in the chats have an idea, a possible way to do it would be to, sorry, I'm going off topic here as we always do this in our chats.
Go ahead.
Sorry. But maybe we could look at setting up a GoFundMe account for the family that they have access to. So there is an email. I don't know if you have one in your channel description, Big Amish, but I do it in mine. So if anybody has ideas on that, maybe if we're lucky enough to be able to set up something like that where it's all online, it's very transparent, and everybody can see where the donations are going to, who's sending it, and what they choose to do with it. Of course, Tony Bruschi will have a seizure if
If he hears that, yeah.
yeah. No.
One
But
thing that,
yeah.
I was just going to say, one thing that could possibly be done other than GoFundMe, if there's an attorney who would be willing to take on as an escrow agent, basically holding the funds and communicating with the family or with the attorney, for example, because what you don't want is a conflict or interfering with the attorney-client relationship that exists. But going to the family, you got to be just very careful. You just got to be very careful.
I think people just kind of meanwhile, they really want to try and assist where they can, and not have the wrong person taking this case.
But yeah, GoFundMe, I don't see if the family has a GoFundMe and it says that, I mean, I don't see what the problem is if that's for the family to use it in that fashion and defining where it's going to be used. So
yeah, let's hope there is a way that we can encourage people if they do want, not a force. If they do want, they can help. Let me go to the next slide. Okay, so you talked here about recusal motion comparison.
Oh yeah, that just the burden. It just tells you the authority that you use, the rule, what rule you use in your motion to file to recuse Judge Hippler. So everything we're looking at is really on the right-hand side. So the disqualification for cause. So that tells you the Idaho Rule 40D2, the canon, the ethical rules binding the judges 211. Specific sworn facts demonstrating the conflict, which we talked about, affidavits being used to get a reasonable basis to support that motion. And then, as it says, the timing window, promptly upon discovering conflict facts. Well, you have it. It's there. It's just putting it together. So if you just look at it, if you just look at the case, it's a fresh attorney is going to be looking at it. Is he going to see this? No, he has to review certain stuff to come to that conclusion in good faith. So just like we're talking about having a bias, if the attorney had a bias towards BK originally and posted that bias saying he believes he's guilty, okay, well, the same holds true. What's the good faith basis for that? Well, you have a posting and has that changed. Well, that attorney now has to review information to come to that conclusion to file that motion, because they verify that the motion is filed in good faith and they've done their due diligence. So every attorney who files a motion, that's what it's under. And then you have judicial discretion. The judge evaluates objective standard and is it appealable? So I think we went over that. The objective standard has been met. I don't see how you overcome that, but it does raise an issue for Judge Hippler. What action is he going to take? Is he going to go to his the chief judge of the court and raise this and ask maybe for a legal opinion, not from the judge himself, but just to raise it and say, I've been involved, whatever he has to clean his hands of, and basically state that he might have a problem presiding over the case? Or does he just stay silent? I don't know. I don't know how you stay silent given everything that's being said in public, let alone what we know in the record. So he has a duty himself to recuse himself when he knows he can't be impartial. Or the imperial.
Interesting to see if he does that.
Yeah, I doubt it. What he's going to say, do you find, he might bring this up at the hearing, do you find any basis for my recusal? Imagine you're just appointed as the attorney. What do you say? It raises, no, Your Honor. I have to look at I have to review the record. So, and he's going to have to discuss things with Ann Taylor and the defense team. He has to. And I'm sure Ann Taylor is going to tell him exactly what we're talking about, that the judge should be recused, and here's the reasons why. And I will provide an affidavit supporting your motion. So now you have a good faith basis for the filing. That doesn't require you to go through the whole 68 terabyte data. And then you have the other attorneys, and then you have the experts. Syre making statements about the judge's rulings and how he was going to admit evidence. He's going to admit all the evidence in that would have basically convicted BK 10 out of 10 juries. Sorry.
Yeah.
There's a lot there. There's a lot there to unpack. So I'm sold 99% that a motion to recuse should be coming. That's number one. And the basis for it we outlined. So it's just a question of when. And certainly Ann Taylor's affidavit and the others possibly would be involved. So, but I expect at least one affidavit to be included in that motion to recuse, because that'll provide the good faith basis for it. And obviously in that motion, they're going to identify the statements made by Thompson, Steve G, Syre, whatever.
Wickham, Turvey.
Wickham, yeah. They could, just to make it fun.
Put everyone in there.
But yeah, no, but I can't wait. I mean,
do you want me to skip past this one?
I think we're done. I don't think the duty to recuse. I think is.
Let's see. There's 10. Let's go to 11.
Oh.
Okay, so steps in a recusal challenge. Do you want to go over that?
Yeah,
Good.
just we're talking about investigation because you have a new attorney who's not investigated anything. Ann Taylor knows, but investigation. So what do? You immediately contact the prior counsel and the defense team, and you get all the information you can, right? That's one. Two, then you go, if you have the information and you believe in good faith that grounds exist for the recusal with cause of Judge Hippler, then you draft the motion and the affidavits, right? Under the rules that we talked about, Idaho Rule 40D and 25. So, and you have to support him with an affidavit. We talked about that. Ann Taylor, most definitely involved, or at least one of the attorneys, but I believe it's going to be Ann Taylor. And if it's not Ann Taylor, you're going to use the public statements of Steve G and incorporate that into an affidavit that could be used and signed by Bryan Kohberger. So you don't leave any stone unturned. You use whatever you can. But for filing the motion at its initial stage, all you need is a good faith basis for it, and that you satisfy the elements for recusal, and that he's not impartial, or the improprieties that we discussed, wearing the dual hats, and the defective plea, and the de facto Alford plea, shall I call it, and maintain that. I like that, de facto Alford plea. So that gets you past the dismissal stage. Obviously, the state's going to file in opposition to the motion, but if it's supported by an affidavit for the facts supporting recusal, you pass the initial dismissal stage. It goes to, then you were talking about the judicial determination. So the presiding judge, and this is where it's hard. How does the judge apply 211 objectively on his own conduct? It's, again, an oxymoron, but could he do it? He could ask, could the parties consent to allow?
How would he do that?
Technically, it kind of creates a conflict, an inherent, apparent conflict that he can't overcome. So he would have to remove himself and just have a judge to hear this part of the case of his recusal. Now, could he remain and defy the obvious recusal facts being alleged? He could, and he could say, he could rule on it, but it raises more and more problems for him down the road. But could he technically stay on? It's going to be up to the chief judge in that courthouse is going to have problems. He's going to say, what's going on? There's too many eyes. And how do you address it? So it is an inherent oxymoron that he can't escape from. This is the Pandora's box that Hippler can't avoid. How could you rule over your own recusal? You could, but if it's based on all the things that, all the facts that we suggested, and an affidavit, and the statements of Steve G. and Thompson to support a de facto Alford plea, and the plea negotiations being basically manhandled by Hippler, that's hard to ignore. So, objectively, he shouldn't. He should recuse himself. That's if it's filed. Now, what if the attorney has been picked as a Trojan horse? What if he's a fixer? I'm not saying he is. There's no evidence to support that. But what if an attorney is handpicked to basically bypass a recusal issue?
It wouldn't surprise me.
Say again?
It wouldn't surprise me with him.
Yeah. And then it's waived. You see, then you basically use somebody, and you use that somebody to, is BK going to raise it? What if he says, I don't agree with you. I want you to file this motion to recuse. And the attorney says, I don't see the good faith basis for it. There's no facts to support it. But my prior counsel will provide it. Well, she's ineffective for a reason. You see how you could, the gamesmanship. So if someone wants to create a wedge between the recusal and the defendant's rights, this is where it happens. But this is why it has to be vocal. BK has to be vocal if that happens. And just like he filed, and I don't know if people know this or not.
My thought is he's going to be.
What's that?
My thought is he's going to be.
I'm sorry. He's going to be what? The appointed counsel?
No. I think he is going to be very vocal about this.
Oh, Yeah.
Yes, sorry about that.
Yeah, no, I was thinking ahead what I was, and I apologize, low brain power today. So even if you have an attorney, BK could actually go against his attorney's advice, and he could file stuff on his own. It'll raise questions, but he could do that. And he could do that and say he doesn't want counsel, but he could certainly file it. He could file something with the court. That's why it's going to be so interesting how this is going to be dealt with, the whole process. And Judge Hippler, is he going to require sealed submissions, filings? Because that way we don't know what's going on. The public is not going to know what's going on. And the basis for sealing, you could say that. So all this, I mean, there's going to be a lot happening. A lot happening in very short order. But the new attorney, again, there's a scheduling order that's going to go out where basically the judge sends out, come in for an initial hearing, just want to introduce ourselves, and then we're going to set the calendar for the PCR. So that's going to happen, I'm assuming, for our initial conference. That hasn't been set, I don't think, to my knowledge. It could have, but I don't know if it has. And if it has, I don't know what date. But to my knowledge, it hasn't. There's no initial scheduling hearing set. But that's what's coming up. And then basically the attorney will introduce himself and provide all the issues that he may have to go through in order to address the PCR that's been filed by BK, and tell the judge, I need X amount of time. I have these discovery issues, the data issues that I have to go through. Whatever it is, he's going to alert the court as to what issues he has in proceeding with the PCR and as far as time's concerned. So, and this will be a great time to see BK as well.
Do you think we're going to see him on the screen?
I don't know. That's a good look. The initial hearing, technically he is in protective custody unit. So there are difficulties by moving him around, but it is in Idaho. I'm not sure how difficult that is necessarily, but and it might be in his best interest not to be there and present because of any safety issues. They could always use that as a reason, pretext or not, to not allow him to be present. I'm assuming he would want to be present, but if they raise a safety issue, then potentially he doesn't have to show up, and he could show up via Zoom or other video transmission to the court, whatever they have available. So that's how it would happen. So if he doesn't physically get there, he'll probably be on a camera, which kind of what happened in the Tyler Robinson case with some testimony, or at least what was the his friend's name, but anyway, it was a video statement that he provided. But that's available because it's initial hearing. Basically, they're not hearing any arguments. It's just about setting the table as for the needs and the issues that need to be addressed involving time and or materials, resources. Those are the kind of things that would be discussed.
Okay, do you want to go to the next one?
Oh, that's it. We're done.
That's it. Okay. All right, that's it.
Yeah. Let's see. I'm gonna look. So there's a lot, there's a lot of administrative work that goes into it. And that's what the first hearing's all about. And they set a calendar to address it.
So this is where we kind of bring in what you've been working on. Do you want to talk about that? Not yet?
Oh, yeah, I guess, well, here, yeah, I guess we could discuss it. It's regarding judicial integrity. I was
You
talking
don't
to
have
Wendy
to.
and,
I don't want to put you on the spot.
yeah,
We could
I guess
bring it up in our next video.
or we could discuss it, and that's fine. And but just people to know, we're discussing a petition that we could send as under our First Amendment rights as a grievance against the government, in this case, the judicial branch of government, and how we feel that there is improprieties of Judge Hippler and point them out, specifically Steve G's statements and Thompson's statements, and the biased rulings, the fact that he's wearing two hats as an investigator and presiding over the plea, creating an inherent conflict that wasn't waived because it existed at the time of the plea and the judge knew it. So it did it only to bypass those requirements. So there's a petition drafted that we want the public to be involved in, that it gets submitted to the chief judge of the judicial district overseeing the PCR. We drafted that. We have a letter to the governor, a cover letter that basically adopts it, and a letter going to the governor. Not that it'll be helpful, but it's just going to all the persons who would have an interest in the case, as well as the two U.S. senators in Idaho, Mr. Crapo, and I forgot the other gentleman's name now off the top of my head. But all of that, and submitting it. And I don't know how.
I think I saw Governor Little.
Yeah. And I don't know how people feel to be involved, but it's just involving a QR scan, an electronic identification of, provide what you want, your YouTube handle, email, just your location, just general stuff, no phone number unless you want to.
Yeah, to be completely private.
Yeah, it's just your location and some sort of identifying mark. So that we put together. I think if you want to show it and we could go over that, sure, why not? And if this doesn't interest anybody or the public, then maybe we just cancel it. But I do think it's something that people have a huge interest in participating. They feel helpless in seeing not just BK's constitutional rights, but all of our constitutional rights being affected by such conduct, assuming it's true, as alleged in what we've been exposed to publicly. So, yeah, there's a public petition seeking, informing the chief judicial officer, the chief judge in that district of the PCR now handling Bryan Kohberger's case, to seek or investigate.
Highlander, sorry.
Yeah, no.
Highlander, how are you? Sorry, Big Amish, go on.
No, you're fine. Yeah, Lucy, I'll try not to send. We'll try not to send nudes. That'll be a sight. But I think it's a great way of the public participating directly and saying, at least investigate the conduct under. Here's the standard. So, and we're petitioning the government, the judicial branch of government, of our observations, our reasonable observations, objective observations of the conduct of Judge Hippler and public statements that bring his conduct into judicial disrepute. That's basically the premise of the petition, but it lays it all out. What the purpose is, that it's Idaho's citizens of Idaho, the United States, and the world. All the eyes are on Idaho. And so there is a public interest in addressing this.
Let me see if I can bring up his petition while you're busy there. Um,
If you could bring it up. So I'm glad some people are agreeing with it. Well, good. Yeah, that is exactly what we need to create a public, basically a public hurricane that will overwhelm the judiciary of Idaho in investigating this. Even if no motions filed, that the outside public petition will force the chief judicial officer, the chief judge in that district courthouse to review what we allege to be apparent, if not actual, observable misconduct by Judge Hippler. It could
Okay,
only
I
help.
can't really bring it up because we didn't put it into a document yet. I think once we put it in a document, then we can probably bring it up.
You want me to send it back? Because I'm gonna.
Have you got it in a document form for me?
What did I do? I think I sent it to you as a link.
Yeah, there's a link.
Are you able to cut and paste? I'm trying.
No, Linda. If you've got any information, do you want to share it with us? Sorry, you're having a bad connection.
What we could do, Wendy, rather than let me
Share
see what I
it
can
on
find, because
email.
I'm at a whole different computer. But I did send it by email, but that's just a link. Let me see how I could
Yeah,
convert it. Because
the link. So,
I'm old and slow. Technology is not my game. I'm like Thompson. I have to wait for Josh Hurwitz to bring in 68 terabytes and dump it. Oh man.
What I can just show a bit of it if you want. Let's see if I can do this. Gosh. Okay, hang on. I might be able to do this. No, it's cut off there.
Let's see.
What did I do? Okay. Sorry, no, I did something wrong here on my side. Anyway.
I might be able to solve it, but I've not been on top of my game here.
All right, let me just take a little bit of screenshots and I'll share it like that if you want. And then I'll show a little bit of it. I think this is the only way that I can do to do it. All right, so I'll just show a little bit of it and then we can take it from there. Give me a sec. Let me just.
We could eventually post it. I think we both agree it's pretty much ready. Want to add anything to it? Maybe we just post it on our channels as our joint collaboration on it. I think that would be great. What does the chat think?
Okay, let's see what they think before I put it on. I'm also struggling with signal a little bit, Linda. Sorry about that. Been a long day.
Yeah.
And for Big Amish, he's been working on this all night. Did you sleep at all?
That little window, that 3 hour, that was a 3 hour window. And normally I get up, I'll take a walk because I don't sleep great anyway, but about 5:45 and 6 o'clock, I'll get up usually quick, just for a quick 15-20 minute walk. But that didn't happen today. I was exhausted, so I'm staying up.
Sure. Yeah, Linda, you can mail me for sure. All right, let me just. I'm moving between two phones here. Sorry. Let me do this.
And I'm sorry. I should have had that.
Absolutely, you can send me a mail if you want. Don't stress. No, we would. I was also running a bit late today. Let's see if I can do this. Okay.
Let's see.
You can hear click on my side. It's because I don't know what's going on with this device. One.
Oh, here. Okay, let me see. I have it in the email. So you have it in the email, right? That I sent you. Let me. How now? Can I?
Let me see here. Okay. No. I think
I could send it again, or let me see if I could convert it real quick into.
No stress if you can't.
Could I forward this to you? Let's see. Oh shit. Sorry.
No, you can't. I don't think you can convert it like that because it's. Just trying to open it here. Sorry. We've also been struggling with the internet today. Wow, it's been crazy. Okay, let me close this and try again.
Forward, translate, filter.
Technology. Oh, thanks, Linda. No problem. I really appreciate that. Look, we always say we learn a lot from the chat as well. So that is true.
I could print them. I could print it, like make a PDF out of it, and then send it to you. That way, it'll be a PDF if that helps, or would it not? Because
You can. I just no. I'll just what I'll do is I will just save it and put it on. Let's just do this quickly. We'll just show a little bit of it, and then when you get ready, don't worry.
Okay.
I think that's the first page. Sorry, guys.
You're fine.
I don't know why everything is so slow here today. Something is slow. I woke up and there was like the internet went on and off.
Signs. Those were the signs.
That's why I always write in a little book because it's probably easier for me when I do that. Okay, I'm almost there. Almost. Oh, wow. This is good, yeah? Sorry. Almost there.
Yeah.
That's why I always write everything in a little book. I am still pretty much like that. If I want to save anything, I have lots of little papers and notes. Okay, let's see. If I can bring it.
They always come in handy.
Okay, let's bring up the page 1. Wow. I don't know what's going on with this.
Well, if you
Guys,
can't,
if you
what?
if ever you want to save something up, I promise you, just yeah, just buy yourself pens and papers.
Yeah.
Okay. All right. Let's see. Oh, okay. Sorry, I was pressing something completely wrong. Thank you. Sorry, I think I got it. I hope. Nope. Wow. Okay,
You
you're
got
going
it?
to see something happen now. It's so slow, but it's
Yay.
going to appear.
You got it.
I'm thinking I'm like crazy. It is slowly appearing. You can see a little circle buffering there. Wow.
It matches the quarter moon.
Can you see? Can you see it wants to appear on screen? Sorry, guys.
It's part of the celestial effects of the background.
Oh, let's add it again. Come on. Please come on stage. Shine. Got stage fright. Wow.
Let me see if I can.
It's not from your side, it's from my side. My internet is terrible.
Oh, okay. So you can't even. Oh, I see. So it really
No,
doesn't matter.
even if you send it to me, it's going to do the same thing.
Yeah.
Wow, that is crazy. Let's try something else. Okay. Let's try it a different way. Okay. So, that is strange. Sorry, guys, my internet.
Oh, you're fine. Yeah. Let's see if,
That's so strange. Okay, well, don't worry. We're not gonna. I'm just gonna leave it. Okay, we can show it to you guys next time. It's not going to load for some reason. I don't want to cut us off the stream anyway.
I think here. Let me. If it doesn't let me. Why not?
Do you have an option to put it on from your side?
I was trying to do the PDF because I think I'm trying the first time I've ever doing this, but I thought if I converted to a PDF, it would allow me to show the file, but it's not. I wonder if I make it. Could I do it as a JPEG or something? So I could under the presenter. It's not of it. Slides in PDF. Oh, here, slide in PDF. You have no slides. How do I add it? I just
Okay, so you go there to present.
Oh, Google slide. Oh, my computer. Hold on. Again, this is the first time I'm doing this. Hold on. We can support Google on PDF video. Hold on. Here we go. I'll have our emails on it, but do you see it? I put it in the. It should. Are you able to? I don't know if I have access or you do, but it's in the.
Oh, here we go. Let's try. Oh, way, yay. Thank you, Big Amish.
All right. Everyone read that?
Yeah. Thank you, guys. Thank you, Big Amish. I thought it's my internet. Sorry, guys.
Yeah.
I'm old.
So if you want, scroll down because the first four are just those cover letters.
Okay.
If you want to go right to the petition, it's number 5, page 5.
Tell me when 3, 4, 5. Okay. There we go.
So you got it right here. Let's see. And again, formatting, it's because of the formatting's off showing it here, but it's not on the actual word processor. But
Okay, can you guys see that on the screen?
Well, if you want, you want me to read it? So go the page right before that so they could see it, but that's the end, the relief requested.
Okay. Previous one. 4. Okay.
Yeah. Okay. So there is. Wait, now why is mine? Hold on one second here. Okay. So everyone's seeing. I'll read the summary, the petition summary. Obviously, you see the caption. The caption is a little off, and it talks about to the Honorable Chief Judge of the 4th Judicial District. It has the emails that are going to providing copies to the specific individuals. You have the petition summary and statement of purpose. Here it is. We, the undersigned, citizens of Idaho throughout the United States and across the international community, respectfully submit this petition to illuminate critical procedural defects, apparent or actual judicial conflicts, and structural concerns in the post-conviction relief proceedings for the state of Idaho v. Bryan C. Kohberger. The world's eyes remain firmly fixed on the state of Idaho. The case serves as a benchmark for how due process and fundamental fairness are executed within the American legal system. Idaho must demonstrate that it upholds transparency and constitutional integrity. Judicial power is not subject to public scrutiny, and light risks systemic abuse. To allow the Honorable Judge Stephen Hippler to continue presiding over PCR matters without recusal threatens to bring both the Idaho judiciary and the U.S. judicial system as a whole into lasting public disrepute. And we talk about the constitutional framework. I don't necessarily have to go through all that, but it talks about Hunter, and it talks about Rule 33 under the Idaho Rules Manifest Injustice, how it's incorporated into that. And then the grounds for recusal. This is the part we talked about, but direct judicial involvement in plea negotiations and material witness status. Statements from public observers and victim advocate representatives, including Steve Gonzalez, have directly cited Judge Hippler as initiating or being actively involved in plea bargain discussions, including de facto Alford framework considerations, where a presiding judge participates and oversees the structural parameters of plea negotiations. That judge becomes a material witness to the voluntariness, scope, and potential coercion surrounding the plea. Under Idaho judicial rules, a judge cannot sit in judgment over post-conviction proceedings where their own actions constitute material evidence. 2. Procedural prosecutorial statements on the absence of allocution. The record reflects an absence of narrative allocution by the defendant. Public statements made by lead prosecutor Bill Thompson immediately following the change of plea and sentencing hearings explicitly confirm that the prosecution did not require a detailed narrative allocution. Prosecutor Thompson stated publicly that asking for allocution was deemed unnecessary if the state anticipated the defendant would simply minimize his involvement over self-serving statements or lie. Even if the murderers talked about it at some point, whatever the murderer said wouldn't make any sense to ordinary people like us, and it will mostly be self-serving. Prosecutor Bill Thompson quoted Fox 13. The reliance on non-admitting restricted yes-no colloquy devoid of narrative allocution raises foundational questions under the Hunter standard as to whether the plea was truly knowing, voluntary, and uncoerced. Give me 1 second, my
It's okay.
the dual role administrative and adjudicative conflict. A structural conflict of interest arises from the simultaneous administrative oversight of state media leak investigations, including leaks to national outlets such as NBC and Dateline, alongside ongoing trial proceedings, accepting or enforcing final dispositional outcomes prior to resolving administrative leak probes, risks public trust and brings the administration of justice into disrepute. 4. Structural coercion via discovery delivery. Denying trial postponements following the late stage delivery of tens of terabytes of technical discovery created conditions characterized as structural coercion. Evaluating these conditions under Rule 33 requires a neutral judicial officer who did not issue the underlying procedural denials. Relief requested. Wherefore, the undersigned petitioners respectfully request that the chief judge of the district court reassign the Kohberger post-conviction relief matter to an independent district judge completely unattached to the underlying plea discussions, administrative leak probes, or trial rulings. Ensure all evidentiary hearings regarding plea voluntariness, discovery timing, and judicial conflicts are evaluated under the Hunter/Rule 33C miscarriage of justice baseline. Reservations of rights and protective clause. Notice of constitutional protections. The petition constitutes a formal exercise of the petitioner's rights under the First Amendment to the United States Constitution and the Idaho Constitution to petition the government and judiciary for a redress of grievances. Any act of harassment, retaliation, intimidation, targeted surveillance, or adverse administrative action directed against any individual listed below as a result of signing or submitting this petition shall be explicitly construed and treated as an intentional infringement upon protected First Amendment rights and a violation of federal civil rights. Then it goes to the petition signatures. So respectfully submitted, petitioners for judicial integrity. And basically, Google will provide us that QR code, and individuals could use that QR code and sign the petition that way, electronically.
Yeah, it means anybody can sign it.
Anyone could sign it, yes. Yeah, so this will get submitted via email, and then the QR codes would satisfy the signatures for the petition. Anyone have any questions? Did I do a bad job of reading?
No. This is very well put together. Thank you, Big Amish.
Yeah.
Okay, so what happens when you send this to them?
Well, we follow up. So one is, did the judge receive it? Is it, how is it going to be handled? So follow up with questions to the judicial clerk. And there might be one administratively when it comes to judicial ethics and how it's going to be handled. So there'll be follow-ups to make sure that's being addressed. They might not address it at all, but that's why we have cover letters going to the governor, going to the U.S. Senators that we identified, and you could even send it to your own senator. So we could have this available for individuals who want to send this to their own U.S. senator, because the Judiciary Oversight Committee in the U.S. Congress has oversight. Because again, when SCOTUS talked about the judiciary being in disrepute, it controls the whole judiciary. Even though it's a separate state sovereign, the baselines of what miscarriage of justice is embedded within that state rules or constitution. So there's many ways that it could be helped. So
Wow.
even sending it to our individual, and and even in South Africa, this could be raised because ultimately it's about fundamental fairness. It's due process, fundamental fairness, that everyone recognize what's fair. Here are the rules. What's fair? Why are these rules not being applied? whether it's with the FBI, DOJ not following their own rules and procedures of obtaining evidence, materials, or testing it. There's always these back doors. That's not due process, right? And they're using technology ahead, or that's not been yet ruled on by SCOTUS as an avenue to use these technologies to abuse due process, fundamental fairness. But this could be raised globally in your local communities as well, or local government, federal government, and say, how's this happening in America? How is this possible that a judge provides all this? And
You?
there's different ways anyone could help, but being silent isn't one of them. Silent allows evil to grow. And this is kind of what we're looking at, isn't it? I'm not, well,
Yeah.
it suggests that. I'm not saying maybe there's information we don't know about. But everything that we've seen suggests there's a big problem with Judge Hippler presiding over this PCR. That is a fairly reasonable conclusion to make. So,
I think everybody agrees with that.
yeah. I think
Love and Other Habits. Hi. Oh, Johnny, so you're quite a ways from me. Durban Bluff is very nice. Very nice there. Love and Other Habits asked you if you watched the EWU hearing. No, I saw something like that come up. Did you see it, Big Amish?
I did not. And I think what is that? I forgot who's. I think that was a content creator. Is that Lana? I can't remember now, but filed a lawsuit regarding the getting public information, if I'm not mistaken. But I've not seen. I've not seen that at all or watched. If there was a hearing, I did not watch it. I have no idea about it.
No, when was it? Was it today?
Oh, if it was today, I saw. Yeah,
Yeah, I think we should definitely have a look at that.
Again, it's a multi-prong approach. So one's going to the judiciary, the petition. Two, it's going to the governor of Idaho. Three, it's going to the U.S. senators of Idaho. Four, it could be to anyone's U.S. senator. So if you're in New Jersey, New York, California, doesn't matter. Due process applies because it's a federal constitution that's being violated. And so an injustice somewhere is an injustice everywhere. That's a famous quote by MLK that resonates, and it does resonate so much. Even more so now. I used to think about it in different times, but in different contexts. But this might be a small injustice to some, I think. But it really affects us all. That's why it's so powerful and so necessary to address what's going on. And at least have a neutral judge to rule over these cases. That's what the minimum due process requires. And being treated fairly, being given the raw data that's being concealed, being able to question the analysts of DNA, the algorithms of Othram, how they amplified it, how reliable it is, testing all that, testing every piece of evidence and the source of where it came from is pivotal to due process. It's about fairness.
Yeah.
So
Absolutely.
that's where we are. So hopefully someone is looking at this and could be helped.
Well, I think what we'll do is we can make maybe a short on it, and then also because we kind of brought it in a bit late on the video, and then put the link on the short.
That's a good
Or
idea.
you put it as a post. I think that might get people to notice it a little bit more. And from your side, they might notice it a bit more because I think the algorithm is not on my side here in South Africa.
Ah. Well, okay. Yeah, I think that's a great idea, Wendy. Making a little show, cutting this up, and 11 other habits. What happened at the hearing? Just quickly, if we can, do we? You know what
Yeah, we
happened?
haven't watched it. If you want to tell us, I wonder if there is a video on it we could look at.
Yeah.
We could kind of look at it quite a bit.
Yeah.
Let me see if I've got it.
Yeah. I'm assuming when she says it didn't go well, the level of lawyering differs in every area, right? And so you always have to pay attention on someone handles a case and what they're willing to do, and creating a record below. So don't know what happened on this public information request, and then the Idaho Public Information Act, I guess.
If anybody has the link, you can put it in the chat. But Linda, yeah, you're right. I think, when you speak to people, they seem, it's not really interested in this case too much. And they kind of distance themselves. I think average people do that. They're not too invested in this case because they think it can't happen to them.
If it could happen to one, it could happen to all of us. That is that's why I mentioned that MLK quote. It is so true. And, there's some things that we can't do, right? There's certain things we can't do, but there's certain things we can do. And just discussing it is something that we're doing. Just discussing it is a positive move because there's individuals who don't even know about it. And maybe they're...
You're wrong, Big Amish. We're big, terrible conspiracy theorists.
Wait, what? What did I miss?
We're terrible conspiracy theorists. I probably get an online assault every single day for saying that this case was mishandled. Every day.
And we're conspiracy theorists. Well, objectively looking at it, I don't think there's any reasonable person who, if they listen to what we laid out in this show about Judge Hippler, objectively looking at it, believes that Judge Hippler was an objective judge. Too much objective.
I think most people don't even look at that. So even questioning the case means that you're a pro-burger.
Oh.
But or even asking a reasonable question. So I don't know if any of you have mentioned anything online with, when you see something come up, you might question, okay, but explain this to me, or you might bring up a point about the case. And wow, the comments. So I think most people are starting to question things, especially after this documentary came out. But yeah, they'll try every insult in the book. It's actually quite funny. Lucy, you too. You also have people that hate you. I'm telling you, I have more enemies with this case than I think I could have possibly imagined.
She has a
We
gaggle.
don't hate you. Big Amish is still gonna get there, but he's kind, so people won't hate on him. But
yeah, slowly hate me, grow to hate me. How about that? But that's fine. Everyone has their own opinion. That's fine.
This is the thing I never understand about this. I've always said with people, if you believe that Bryan is guilty, that's fine. You're entitled to your opinion. I'm not going to change your opinion on it at all. But why are we wrong for questioning things that don't seem correct?
Well, questioning should be part of our civic duties. Just human. You should always question. I mean, we question our parents. We used to do that growing up, right? And all of a sudden, you don't question because these new norms that are being pushed. Don't question the government. That's the antithesis of a democratic government. So
It's true. Wow, Linda. Yeah, people, they say, oh, it can't happen. Oh, that's a wild statement because you're not a murderer. Clearly, people that say things like that have never seen real corruption in life. But I mean, that's right, Johnny. Well, 10 hours. I actually had somebody today. Wait, let me read you a comment. There was somebody. I'm going to read you a comment from here. So, let's do. It said yes. Okay, let's go. Yes, under my comments.
yeah.
It says to me.
Let's see.
Yes, I enjoy watching Tony. I enjoy watching Annie Elise, Dr. Gary Brocato, Nancy Grace, because these people advocate for victims and they provide interesting, informative content. So I'm not your target audience. And then she says, what is this comment? Oh, I didn't see that one. Wait, give me a sec. Quite interesting how people come out with comments. Oh, this one. Oh, this is also right. She says, you ask why Dylan couldn't identify BK in a lineup. If you come that close to someone, you can identify them, ? He said. And then he says, she said, in capital letters, he was wearing a mask. Have you not followed this case at all, you dumb bitch? Okay, great. Eyewitness testimony is proven to be notoriously unreliable.
Yes.
Okay, but then why is it part of the probable cause affidavit if it's unreliable? So anyway, she says. And then he says, DM changing her story isn't exclusive. It almost always happens. People misremember things, especially during traumatic events. Do some research, you dumb idiots. Hi, Jethro.
Hey, Jethro. Good to see you. So wait, Lucy's saying, if you aren't asking questions, you are anti-American. No.
Yeah. But Lucy, this is not even only American. This can happen all over the world, right? And this is the problem. I mean, I sometimes feel like my channel doesn't have, I don't have like a fancy schmancy intro and 30 people working for me and controlling everything. Just now when I had this little, oh wow, I can't even bring up the image and we're just talking. But these people obviously, they trust these big channels, but what they don't realize is that they're reading from a teleprompter. We're talking here, I'm listening to a lot of things you're saying, learning from you because we don't claim to know everything. But that's where those big channels come in and they have a tremendous amount of influence over people. I think people don't realize that Nancy, Annie, all those people have an entire team of people working for them in the background. I think Nancy has about 30 people in her control room.
Yes.
So
that's a lot.
That's why,
mentality.
Yeah, and that's why they say, because they bring informative information, because they've got a whole team of people that set up their teleprompter, done their makeup, their hair, and put a really expensive microphone in front of them and said, okay, go for it, roll, do whatever we tell you. There's a $5,000 sponsorship waiting for you, or 3 of them in this video. If you say whatever we want you to say, well, there's $15,000 in your pockets, plus sponsorships, plus ads, plus. So those are just some of the comments you get from people, and yeah, it's pretty interesting as well. They love to argue with us.
But they're content. They nothing's gonna. They don't want anything affecting their narratives or their gravy boat. So they follow what they're being told, and that's why they're
Or
hired.
this one, this comment here. Poor Bryan was dumb enough to admit to killing 4 people. If what you're saying is true, he's a full-blown dumbass. You see how these people are? They're crazy.
Yeah, you have to, in order to fairly judge BK, you have to be able to be in his shoes, and be in his shoes during these times that we're discussing violative of due process. So unless we could do that, we could see it, we could sense it, right? And I believe most people have a good sense of fairness.
Mhm.
And that's why this case is resonating like it is, because at the baseline, I'll use that term, our federal constitution in our own soul is telling us there's something wrong.
Well, we know it. I mean, one of the worst comments I think I had recently was, and this is people's mentality. Somebody commented and said, how can you advocate for Bryan Kohberger? Have you seen his nose?
That's
What? What does that have to do with anything?
It doesn't. You're right.
Going back to, have I seen his nose? Okay, he's
I'd
got
be
a
in
big
prison for
nose.
that.
He must have. Yeah, he's terrible. Scully, how are you? Let's see. Did you send me something?
Scully sent you nudes, screenshots. What? Scully.
Okay, no, he didn't.
Okay.
No, I don't think he'll do that to me.
I hope not. He wouldn't. Scully's great. He knows I'm
Yeah,
kidding.
we love him. No, he wouldn't send that. I didn't get anything, Scully. I didn't. Don't worry. I've also timed some. I think I blocked somebody from my channel by accident once. So if anybody sees I blocked them, it wasn't. I wouldn't block someone. I just pressed the wrong button. But yeah, just going back to those comments, like, so somebody will say, "Have you seen the size of his nose?" Or the whole family is crazy. They all have those psychopath serial killer eyes. And, that's the mentality of people that we're dealing with.
Yeah. No, everyone might have a bias, but using, like, you could, but using someone's family or looks or, okay, that's the first thing we see, right? Okay. But to just rely on that to come to a reasonable conclusion, that's unfair, right? That's really what it is.
Yeah, it's very unfair. And that's where the media is very unfair in all of this, because remember those images that were released of Bryan, the selfies that he took, and
Yes.
you remember
100%.
those?
You're right. Oh my God.
It was a big think about that.
He's holding up his thumbs up for committing 4 unalivings. I'll never forget that. Like, oh yeah, that's what you do. You take a shower and you give the old thumbs up.
That's one of the craziest theories I've ever seen. Who was he giving the thumbs up to?
I think he sent that picture to his mother. I think, if I'm not mistaken, it was like an early
Yeah,
morning.
it could be anything. So they made a big meal out of that picture. Scotty, do you remember that as well? With him in the hoodie, because they said, look, he looks like Ted Bundy here. But
Yeah. That
so,
was
I mean, look, I don't know who's got teenagers in this chat, but they all look like that.
yeah. Yeah. You should, yeah, they just demonize them just outright.
Yeah, they do. I mean, if any of you have a teenager in the house, they'll walk around with a hoodie when it's like 100 degrees outside. How's it, brew? Take that hoodie off. But it doesn't mean anything.
Yeah, no. I sometimes wear, I wear that to sleep sometimes if I feel cold, especially during the winter, but no reason not to. But yeah, that's so common. That's so ridiculous.
Show us your picture, big Amish. Do you look like that?
I don't want to be framed for any future murder. Oh, that's funny.
Let's see what the chat says. Yeah, that's true. Linda, I wish I'd felt like that as well. I didn't in the beginning, Did you feel that something was off right in the beginning?
Why I came into the picture on that plea hearing. That's when I thought there were problems.
Did you, Big Amish, did you come into this when they did the plea as well?
Well, that's the first time I looked at anything, and that was the plea. I watched the hearing, and I said, "There's a problem here." Just the way they were allocuting, it was just very weird when you had so many people, such a huge public interest, and there's no allocution. Yes, you could do it under the rules, but the allocution has to be corroborated through other sources, if not the actual defendant. So it's not that they just do away with it. They need either to rely on the PCA or a proffer of some testimony from someone. I don't think that existed.
So we came into this case pretty much at the same time. I was going to cover it. I didn't really think anything was wrong until the plea happened either.
Yeah, that's it.
But yeah, so Temu ER patients, yeah. You bring up a very interesting point there. He's pretty small. My husband actually brought this up one time. Hi, Ida, how are you? My husband and I have talked about this a lot of times because, I bore him with this case, I think, not so much, but he wasn't really interested, but sometimes I'll run my thoughts by him till, like, what do you think of this? What do you think of that? Okay, we're going to watch this documentary. I'm not going to say anything. I just want your thoughts. I should actually bring him up. And he said the same thing to me. He said, there is no way that one skinny little dude like that is capable of taking down 4 students. And so I said to him, okay, but the story is that they were asleep, right? And he said, no, it's just not even possible. It wouldn't be possible because somebody would have woken up and heard this. He's too small. And I actually think I should bring him on. If you guys want me to do a chat with him, he'll explain, because he did martial arts, and he actually does look like a bit of a thug with his bushy eyebrows. And
that would be great. He could add, certainly with his background, that could be very helpful.
Yes, I've asked him questions with it because, I mean, I've seen him. He can, my husband can pick a guy up with one hand. Just kind of like put him against the wall and it's weird. Okay, I think he could do that just by looking at somebody. I've seen the girls cry if he just makes a cross face. He's like that. He never shouts or, um, you know, does anything violent. He's just got one of those faces that, like, no, I'm not going to test him. But anyway, you know what I'm talking about. I think maybe your kids are the same with you, Big Amish.
Yeah, no, I think you're absolutely right.
Give them the look.
Yes.
You don't have to do anything. The look says everything.
Yes, it does.
So if you guys want me to bring him up, I think he will. He's a little bit shy, but when I was talking to him about like the physical possibility of this happening, he brought up some interesting points, and I was like, wow, okay, wow, I didn't think about that or that, and so he's probably listening to us now on his phone.
Come up. But
And he also said, yeah, that little guy, no, there's no ways. I mean, he's pretty small and skinny, so you're 100% right, Tim.
but he had all that adrenaline.
Even with the adrenaline.
No,
So he stopped. He stopped after seeing Dylan.
Yeah, he slowed down. Now he got tired, but he had to clean up. He had to clean up first. Slowed him down.
Yeah, you're right. I mean, those kids were fit, right? They're not small little kids. Look at the size of Ethan. So yeah, Jethro, that's correct. I mean, Ethan is not small. Have you ever noticed how the media tries to make him look like a young baby?
Yeah,
But I mean, that was a big guy.
yeah. Look, it's all screwed up. In every facet, from witnesses, just think about it. Investigation, judiciary, prosecution, defense, regardless. I'm just saying you could argue all these points. Every witness has some compromising, unreliable characteristic. Every one of them. Even in the evidence, the videos, same thing. Unreliable, shady, blurry. You can't make out anything. No murder weapon. I mean, that says it on no weapon at all. Can't find it.
Yeah. Oh, Scotty, what did you send us? Let me just check here quickly. I know that's what we keep saying about Judge Hippler. Why wouldn't you ask him to tell you where the weapon is?
Yeah, at least that.
I think we're going to cover maybe. Oh, okay, Scotty, do you want to cover that tomorrow? I don't know what Big Amish's schedule is, but I can save it. Let me do this. Oh, is it a new interview from Whitcomb? That'll be interesting.
Wickham, okay.
Oh wow, okay. Oh wow, okay, this is good. It's pretty long, so I think we'd have to do another video for it. What do you guys think? Let me save it. Thanks, Scotty.
Yeah, that would be great. That would be good. Another Wickham interview.
Yeah, I think that's a nice story. Scotty, you want to do it with us?
I think
Let me just make sure I've saved it. Sorry. All right, guys. So I'm gonna have to get going. Big Amish, I'm still here.
Yeah.
And then I would say tomorrow should be let's Big Amish tomorrow.
What time you thinking of?
Around 10 o'clock Eastern time. You guys good with that time? What do you think? Let me know.
Yeah, that would work. Even a little
Okay,
after that.
I'm gonna stay with the Big Amish though, and then we'll arrange. And Scully, do you wanna? I can also send you the invite link. You say you'll set your alarm. I'm gonna have to phone you awake.
Well, yeah, I just want to say, when you have a chance, let me know so I just want to give a wrap up on kind of Hitler and the allocution, the lack of allocution,
Okay.
and how it could have solved everything.
Okay. Do you want to go ahead with that?
Oh, okay. So let's put on our judicial hats, and let's say we're Judge Hitler, right? And here are the following facts. One, there's an ongoing leaks investigation, which you're presiding over. So you're investigating a leaks that addresses misconduct by the state. That's number one. Number two, there is a change of plea, and you're involved in the plea negotiations directly and had Alford plea discussions. Knowing that, you fail to allocute, you fail to get one piece of fact, like I used a K-bar knife. Just that alone would have been extremely helpful. I'm saying if we're looking at it, if we are the judge, but knowing you have a conflict in which you're wearing these different hats and you're not neutral, are you not going to get one fact that at least substantiates that he did it? Or are you going to bypass that and rely on a PCA affidavit that is worse in the worst PCA ever imaginable for reliability? Or did you use Molly McMichael as a basis for the allocution? And what I mean by relying on an allocution, it wasn't one, but the judge has to use a factual basis to support the plea. So it has to come from a corroborating source, or that he's relying on it, another source. We know that, I don't know that ever happened. So the plea is defective on numerous levels, and Hitler should have recused himself. You can't be investigating the state of Idaho while putting Bryan Kohberger in jail by the state of Idaho. Does that make sense?
Absolutely.
So that's all. Just in a nutshell, we talked about the evidence much more in detail with Steve G. and Bill Thompson showing us.
Yeah, and then we'll get that link. Maybe Scotty knows how to do this. Probably we can ask him as well.
Oh, the QR code. He would be perfect. Oh, Scully, yeah. Yes,
Scotty,
absolutely.
we maybe what I can do is we'll chat afterwards, and then I can ask Scully, because he's pretty good with this kind of stuff. No, there's no ways. You're right. They didn't do that. Not at all. Not at all. There was no mention of that I know.
So, Hitler, I mean, for bypassing it, it's not a mistake to do that. You just don't do it with all the problems and the lack of neutrality that you were having on its face. That's on its face. We know the investigation was ongoing. Stayed silent on it. Misconduct by the state, you're not saying a word, but yet you'll accept a plea on behalf of the state to put him in jail for the rest of his life.
Exactly. Oh,
So-
wow. Well, guys, I'm going to end, and then we'll see you guys tomorrow. I'll just arrange with Big Amish quickly, and then just keep a look on the channel by around 10, 11, and we'll come back and look at that interview that Scuddy sent. So thank you, Scuddy.
Yes. Thank you.
Thank you everybody for watching, and get that petition out, and then we'll see you guys tomorrow.
Yes. Appreciate you all. Jethro.
Definitely appreciate all of you. I'm not going to name everyone now.
I know. I'm sorry.
But you guys are great. Thank you so much.
Yes. Love you all. See
All
you
right.
tomorrow.
Love you all. See you tomorrow.